Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, for those of you who geek out a lot on this channel, you know, occasionally we like to do these deep geek out sessions where instead of getting into some of the hot topics of today, what we do is we try to get a little bit more intellectual, a little bit more academic in nature, if you would. And in this series, what we're trying to do is help you with educating those that need it. You see, we believe here at Washington Gun Law that the Second Amendment debate is not going to change through either legislation or litigation. No, it is only going to change through education. And when you see some of the bills that are drafted, not only in my state of Washington, but around the country, you realize that many of these legislators have no clue what they're talking about, and most of the voters do not either. I believe that we all have a moral obligation to help educate those who otherwise do not know what they are talking about. And today what I want to do is give you some talking points so that if you're ever in a discussion, in a debate, in an argument, you have some talking points to use when we encounter some of the usual anti-Second Amendment rhetoric. And this is an argument that we see used all too frequently, and so let's talk about it today. So let's spend a few minutes and talk about the Second Amendment only protects those that are in militias. Really? Okay, so like I said, the position that we're going to be arguing against today is this belief that unless you are a member of the militia, you actually don't have a right to keep and bear arms. Now, this argument has been proffered by many people. Most recently, Twitter sensation David Hogg has, of course, been spouting this theory as well. And since, you know, David went to Harvard, that does mean he is smarter than the rest of us. But you see, the problem for Mr. Hogg and everyone else that makes this argument is that nothing else actually supports it. Now, as we try to do here with Washington Gun Law, giving you all the stuff to think about while not telling you how to think, we like to play it right down the middle, and we like to cite our sources. So the sources of today's discussion will be, yes, the Second Amendment itself, to the opinion of District of Columbia v. Heller from the United States Supreme Court out of 2008, authored by then Justice Antonin Scalia, and then finally, nearly every state constitution. Now, to understand the argument, you have to take a look at the language of the Second Amendment, which, as we know, specifically reads, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, for those on the gun-grabbing left, what they believe is that the very first words of this, a well-regulated militia being necessary to the security of a free state, is actually what's considered a conditioned precedent, that an individual's rights are conditioned upon them actually being a member of the militia. Now, you think that's ridiculous, right? Well, you ought to read the minority opinion in District of Columbia v. Heller, because there was not one, not two, not three, but 4 Supreme Court justices who actually believe that that is the current state of our Second Amendment rights. And I can assure you folks, if there is ever a liberal majority back on that court, that line of reasoning could easily be shoved down our throat. Now, if we're going to just use the simple plain English, if that was truly the intent, if the founders and the drafters of the Second Amendment really intended that membership in a militia be a conditioned precedent, why then did they choose the following words immediately thereafter? The right of the people to keep and bear arms shall not be infringed. And so, as you can see, the argument begins to fall apart on simple English. Now, the better news is that the Heller opinion definitively answered this question once and for all. Now, what was at stake in the Heller opinion was the District of Columbia's ridiculous handgun laws, which basically ban the possession of any handgun anywhere in District of Columbia. And this is where the common use test comes out. But more importantly, the scope of the Second Amendment was actually one of the central issues in the Heller opinion. And the court specifically found the Second Amendment of the United States Constitution protects an individual's right to keep and bear arms unconnected with service in a militia for traditionally lawful purposes such as self-defense within the home. And so once and for all and definitively in 2008, our United States Supreme Court specifically stated that the right to keep and bear arms is an individual right, and let us remember how the Constitution was drafted. It is an individual right that we were born with, and the Constitution guarantees that government cannot take it from you. But if that is not enough to convince you of the fallacy of this position, let's take a look at the language used in nearly every state constitution, because let us remember that not only are we protected by the United States Constitution, but our states also have constitutions which provide equal protection and in some instances actually provide greater protection than its federal counterpart. Now, I'm not going to read all 50 state constitutions, but we will kind of jump around the country so you can see the language that has been used, because there will be no doubt that the right of the individual to keep and bear arms is exactly what the Second Amendment guarantees. Alabama, Article 1, Section 26, that every citizen has a right to bear arms in defense of himself and the state. Arizona, Article 2, Section 26, the right of the individual citizen to bear arms in defense of himself or the state shall not be impaired, but nothing in this section shall be construed as authorizing individuals or corporations to organize, maintain, or employ an armed body of men. And interestingly, that is almost verbatim what Article 1, Section 24 of the Washington State Constitution reads. There are many more states that follow this line of reasoning. Arkansas, Article 2, Section 5, the citizens of this state shall have the right to keep and bear arms for their common defense. Colorado has an incredibly wordy amendment, but let there be no doubt, it is an individual right. Colorado, Article 2, Section 13, the right of no person to keep and bear arms in defense of his home, person, and property, or in aid of the civil power when thereto legally summoned, shall be called into question. But nothing herein contained shall be construed to justify the practice of carrying concealed weapons. Connecticut, Article 1, Section 15. Every citizen has a right to bear arms in defense of himself and the state. A state that we traditionally think as being very pro-Second Amendment, Florida. Article 1, Section 8. The right of the people to keep and bear arms in defense of themselves and of the lawful authority of the state shall not be infringed, except that the manner of bearing arms may be regulated by law. And we do begin to see these historical carve-outs for two things. Number one, the state being able to regulate the carrying or bearing of arms. And number two, the state being able to regulate the existence of militias. We're going to circle back on that in a second, because that's going to again show you one of the other fallacies of this position. Idaho, Article 1, Section 11, the people have the right to keep and bear arms, which right shall not be abridged. Indiana, Article 1, Section 32, the people shall have the right to bear arms for defense of themselves and the state. Kentucky has a really interestingly worded one, but it still rings true. Kentucky Constitution, Section 1, all men are by nature free and equal and have certain inherent and inalienable rights, among which may be reckoned the right to bear arms in defense of themselves and of the state, subject to the powers of the General Assembly to enact laws to prevent persons from carrying concealed weapons. Maine, Article 1, Section 16. Every citizen has a right to keep and bear arms, and this right shall never be questioned. Michigan, Article 1, Section 6. Every person has a right to keep and bear arms for the defense of himself and the state. Mississippi and Montana have literally identical verbatim constitutional amendments. They both read, the right of every citizen to keep and bear arms in defense of his home, person, or property, or in aid of the civil power when thereto legally summoned shall not be called in question, but the legislature may regulate or forbid carrying concealed weapons. Nevada, Article 1, Section 11, every citizen has the right to keep and bear arms for security and defense, for lawful hunting and recreational use, and for other lawful purposes. New Hampshire, a state that we probably don't think particularly too amendment friendly, here's what they say. Part 1, Article 2A, all persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. And to give you an example of this other carve-out that we see, which is that this armed body of men is not allowed to be formed. And many states have that, including Washington State, my home state. Take a look at how North Carolina's very wordy constitutional amendment reads. Article 1, Section 30, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed, And as standing armies in time of peace are dangerous to liberty, they shall not be maintained, and the military shall be kept under strict subordination to and governed by the civil power. And so for those of you who think that there is a constitutional amendment that says that you must first be part of the militia in order to have the right to keep and bear arms, but that the state then can ban the existence of militias, that would be no constitutional right at all. Ohio, Article 1, Section 4, the people have the right to bear arms for their defense and security. Oregon, Article 1, Section 27, the people shall have the right to bear arms for the defense of themselves and the state, but the military shall be kept in strict subordination to the civil power. Texas, a state that we normally consider probably likely very pro-2A. How do they word it? Article 1, Section 23. Every citizen shall have the right to keep and bear arms in lawful defense of himself or the state, but the legislature shall have power, by law, to regulate the wearing of arms with a view to prevent crime. And finally, a couple more. Wisconsin, Article 1, Section 25, the people have the right to keep and bear arms for security, defense, hunting, recreation, or any other lawful purpose. Wyoming, Article 1, Section 24, the right of the citizens to bear arms in defense of themselves and of the state shall not be denied. So let there be no doubt. All the case law, all the language, all the state constitutions, that it is the individual who has the right to keep and bear arms. That right was formed the moment you were created. Listen, I hope that you've learned a little bit. I hope you got a few little talking points that you can program into your head. And the next time you're having a debate, an argument, or better yet, just an open discussion with somebody to share ideas and learn from each other, you'll have some things to share. Listen, in the meantime, if you have any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. But if you don't, hey, all of that information is in the description box down below. In the meantime, I do want you all to remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.